Chapter 2. The Scope of the Commission of Inquiry. The Scope of the Commission of Inquiry. The COI terms of reference, as set out in my instruments of appointment, describe what I am required to do. In short, I have to establish whether there is any information that serious dishonesty in relation to public officials may have taken place in recent years, and, if so, whether the conditions which allowed that dishonesty to take place may still exist. In any event, I may make recommendations with a view to improving the standards of governance in the BVI and the operation of the law enforcement and justice systems. In this chapter, I consider the scope of that task, e.g., what is meant by serious dishonesty and governance in this context. Terms of reference. 2.1. Under the instrument of appointment dated January 19, 2021, what I am required to do as Commissioner is set out in 4 substantive terms of reference, as follows. 1. To establish whether there is information that corruption, abuse of office or other serious dishonesty in relation to officials, whether statutory, elected or public, may have taken place in recent years. 2. If there is such information, to consider the conditions which allowed that corruption, abuse of office or other serious dishonesty to take place and whether they may still exist. 3. If appropriate, to make independent recommendations with a view to improving the standards of governance, to give the people of the Virgin Islands confidence that government is working in a fair, transparent manner, and 4. If appropriate, to make independent recommendations with a view to improving the operation of the agencies of law enforcement and justice. Paragraphs 1 and 2. 2.2. 4 points arise in relation to the scope of paragraph 1. 2.3. First, it is uncontroversial that, for these purposes, the term public officials includes ministers and other elected members of the House of Assembly. 1. I shall use the shorthand public officials to include all the officials referred to in paragraph 1. 2.4. Second, what is covered by recent years requires an exercise of judgment or assessment by me. It clearly covers more than the current administration. 2.5. Third, I received submissions from Sir Geoffrey Cox QC and Edward Rissogill, Counsel for the Attorney General on behalf of the elected ministers and their ministries, and the Cabinet, in relation to the proper approach to establishing whether conduct falls within paragraph 12. 2.6. The starting point is the COI terms of reference, which are clear and focused. I emphasize, as I did throughout the course of the COI, that it is not part of my task to determine civil or criminal liability, or to adjudicate between competing cases. Furthermore, as counsel to the COI emphasized in his submissions on this issue 3, my terms of reference are substantially different from those of recent inquiries in England and Wales set up to establish the facts as to what happened, in which there has been a discussion of the appropriate standard of proof, e.g. Sir Thane Forbes' inquiry into allegations of the ill-treatment and unlawful killing of Iraqi nationals at Camp Abu Nabi and the Shaiba Logistics Base in 2004, to which the written submissions on behalf of the Attorney General specifically referred for. On the contrary, paragraph 1 of my terms of reference requires me to establish whether there is information that corruption, abuse of office or other serious dishonesty in relation to officials, whether statutory, elected or public, may have taken place in recent years, emphasis added, but. 2.7. It is uncontroversial that information for these purposes equates to, or, at least, includes, evidence in all its forms and without any consideration as to possible inadmissibility in any particular form, although, as submitted on behalf of the Attorney General, for me to draw a conclusion that it is established that there is information that corruption etc. may have taken place, the relevant evidence, in its proper context, must be reasonably capable of belief, otherwise, as the Attorney General properly accepted. 6. The approach to the evidence, including relevance and weight, is a matter for me. 2.8. On the basis of such evidence, the Attorney General submits that, before I draw a conclusion that conduct amounting to corruption etc. may have taken place, I must conclude that there is a real possibility that such conduct has taken place. Again, although no doubt different words or formulations may be used, I agree. 2.9. Consequently, paragraph 1 requires me to establish whether there is evidence before me upon which I conclude there is a real possibility that corruption, abuse of office or other serious dishonesty in relation to public officials may have taken place in recent years. 2.10. However, that is the subject of two important caveats. Reflecting to an extent the observations of Lord Hoffman in Bvi Children, 7, although the hurdle set by paragraph 1 is modest, given the gravity of the subject matter, serious dishonesty in one form or another involving public officials and, in some instances, very senior elected officials, it is not a hurdle that I would conclude has been met without particularly anxious scrutiny and consideration on my part. 2. Although the definitional criterion in paragraph 1 sets a modest hurdle, the likelihood of paragraph 1 conduct having taken place may of course inform the recommendations I may be minded to make. Therefore, even where I conclude that the paragraph 1 threshold has been met, and, therefore, that there has been conduct falling within paragraph 1, where appropriate and where I am able on the evidence to give a degree of probability that serious dishonesty has taken place, I shall make further observations and/or an assessment as to the likelihood of such conduct having occurred. 2.11. Fourth and finally, there is the scope of the phrase corruption, abuse of office or other serious dishonesty, upon which I sought and received helpful written submissions from Sir Geoffrey Cox QC and Hussein Harry of Withers on behalf of the Attorney General dated June 7, 2021, and further written submissions from the IRU dated the 5th and the 8th of September 2021, and from Silk Legal 8 dated July 12, 2021. The issue was also again the subject of discussion during the oral hearings. 9. 2.12. The stance taken by the Attorney General was that, for conduct to fall within that phrase, it must be criminal. In her written submissions, she helpfully set out the patchwork of the many offences which may be engaged under the laws of England and Wales, including the common law offence of misconduct in office, and under the laws of the BVI, notably under Part 4 of the Criminal Code, offences against the administration of lawful authority. 10. 2.13. However, it is important that I again emphasize the nature of this inquiry. Whilst it is true that the range of recommendations I may make is very wide, and may include, example, a recommendation that an audit, a further inquiry or investigations be conducted into conduct which, on the basis of the information presented to me, may have occurred, I am not myself an authority investigating conduct with a view to establishing whether a criminal offence has occurred, or a prosecuting authority which is required to establish whether a criminal offence is likely to have occurred. I do not have to identify, let alone draft, particular charges for specified offences that may be brought against particular individuals, and it would be inappropriate for me to attempt to do so, such matters being for the relevant BVI authorities. I do not even have to identify particular public officials. Under paragraph 1 of the terms of reference, I merely have to ascertain whether the information before me establishes that conduct of one or more public officials falling within the description corruption, abuse of office or other serious dishonesty, taken as a whole, may have taken place. It is a broad remit. 2.14. The discussion of the phrase corruption, abuse of office or other serious dishonesty during the hearings, and in the later written submissions, focused on abuse of office. Section 84 of the Criminal Code 11 provides, under the heading, Abuse of Office. 1. Any public official who does or directs to be done, in abuse of the authority of his or her office, any arbitrary act prejudicial to the rights of another, commits an offence. 2. If the act referred to in subsection 1 is done or directed to be done for purposes of gain, the public official commits an offence. Curiously, the maximum sentence for each offence is the same, namely 3 years on summary conviction and 7 years on conviction on indictment. 2.15. The Attorney General submitted, and I accept, that this offence plainly encompasses the common law offence of misconduct in office, and indeed goes beyond its scope. 12. 2.16. It is trite that the circumstances in which the offence of misconduct in public office may be committed are broad and the conduct which may give rise to it is diverse. 13. However, the elements of the offence were formulated in Attorney General's reference, No. 3 of 2003, 14, as comprising 4 elements, as follows. 15. A. Public officer acting as such. 2. Willfully neglects to perform his duty and or willfully misconducts himself. 3. To such a degree as to amount to an abuse of the public's trust in the office holder. 4. Without reasonable excuse or justification. Foresight of the consequences of the misconduct is not necessary. 16. 2.17. Where the offense is based upon a willful neglect of duty, i.e. failure to act, then the public officer must be aware that he has a duty to act, or at least be subjectively reckless as to the existence of a duty. 2.18. In any event, a mistake, no matter how serious, cannot be sufficient, nor can a mere breach of duty or breach of trust. 17. The threshold in this regard is a high one, being conduct so serious that it amounted to an abuse of the public's trust in the officeholder. Each of the cases refers to that level as being one where it is calculated to injure, that is to say, has the effect of injuring the public interest so as to call for condemnation and punishment. 18. 2.19. Reflecting the authorities. 19. Before the COI, the Attorney General submitted that whether a breach of duty reaches the necessary threshold for criminal conduct within the scope of misconduct in public office is fact-sensitive. 20. I agree. So, in any jury trial, whether there is evidence capable of meeting the threshold is a matter for the judge, but whether the threshold is in fact met on the facts as they find them to be is a matter for the jury. 2.20. However, there are a number of circumstances in which conduct is likely to be at least capable of meeting that threshold, for example where a public official, including a minister, in the exercise of a statutory power or duty, knowingly takes into account a private interest or any interest other than a legitimate strand of the public interest. Although it is unnecessary for the purposes of the COI to rule out the possibility, it is very difficult to imagine a case in practice in which these circumstances occurred but the conduct of the public official was, nevertheless, incapable of meeting the threshold. 2.21. The public interest is, of course, generally a matter for those who are democratically elected or otherwise democratically accountable, including those to whom elected representatives have lawfully delegated a particular public task. In acting, they are able to take the strands of public interest they consider relevant, and give weight to each as they consider appropriate. However, those who are required to act in the public interest do not have unlimited discretion in how they act. For example, in exercising their public functions, they cannot take into account something extraneous to the public interest. For example, they cannot take a bribe, or favor a relative or associate simply on the basis of their relationship, cronyism, or favor a person or group of persons without public interest justification. In each such case, it is difficult to see how an intentional and grave departure from the standards of behavior expected from paragraphs 3 and 4. 2.24. Under paragraphs 3 and 4 of my terms of reference, if appropriate, I may make independent recommendations with a view to improving, I, the standards of governance, to give the people of the Bvi confidence that government is working in a fair, transparent and proper manner, and, 2, the operation of the agencies of law enforcement and justice. 2.25. As the Attorney General properly accepted, these paragraphs of my terms of reference are freestanding, in the sense that, whilst any conclusion under paragraphs the 1st and the 2nd of may, of course, inform recommendations under these paragraphs, recommendations as to governance and the law enforcement and justice systems are not dependent upon any particular conduct being found under paragraph 121. 2.26. The only issue that arises under these two paragraphs relates to the meaning and scope of governance. 2.27. Governance is simply the process of making and implementing decisions. 2.28. Good governance is more difficult to define. It clearly involves a qualitative assessment of the decision-making and implementing process measured against the agenda or goals which the relevant decisions pursue, and therefore what amounts to good governance is inevitably context-specific. In respect of state governance, the relevant agenda will be societal, political and economic, and governance therefore focuses upon how public affairs are conducted and public resources managed by public institutions, structures and systems, formal and informal. Because, in a modern democratic state seeking economic, social and political development, a crucial responsibility and obligation of government is to act in the public interest. Good governance is seen in terms of characteristics which are likely to result in decisions which maximize the public welfare, i.e. decisions that are made and implemented in the public interest and not for any other purpose, e.g. in the interests of a particular elite group. Thus, in a widely quoted passage, it has been said that the term good governance in a state context involves 8 major characteristics. It is participatory, consensus-oriented, accountable, transparent, responsive, effective and efficient, equitable and inclusive, and follows the rule of law 22. 2.29. In practice, the application of these in a modern democracy should result in, amongst other things, an effective separation of powers, transparent, reasoned and recorded government decision-making, sound and recorded, and, thus, auditable, financial management with budgeting, costings and scrutiny of expenditure to ensure proper use of public money and value for money, procurement of goods and services by the government on the basis of clear and published criteria, involving objective assessment and, where appropriate, open tendering, appointments to public offices and statutory bodies being the subject of open competition on clear and published criteria, involving objective assessment, and an independent public service providing objective and effective advice in respect of the formulation and implementation of policies. 2.30. Good governance in these terms ensures that the risks of corruption and other serious dishonesty in public office are minimized, whilst increasing public confidence in the government systems and decisions to which they are subject. 24. On the other hand, poor governance, of course, increases those risks, and decreases public confidence in the government. Whilst governance is concerned solely with process, in a modern democracy, a stable political system is heavily reliant on good governance, and so, as the elected ministers appear to recognize, the rights and aspirations of the Bvi people to self-determination is dependent upon good governance. Furthermore, as again the elected ministers recognize, in a modern democracy, good governance is also crucial to a stable and sustainable economy.
Disclaimer. Wren Technology Services is registered in the Bvi. We are a consultancy firm that provides technology services. This video, voiceover, is a true translation of the British Virgin Islands Commission of Inquiry report of the Commissioner the Right Honourable Sir Gary Hickenbottom. Presented to His Excellency John James Rankin CMG, the Governor of the Virgin Islands, April 4, 2022. None of the text from the report was changed and was transcribed as reported by the Commissioner. The purpose of the translation is to make sure that the general public would have the full opportunity to hear the text as it is presented in the report. Wren Technology Services or its owner has no political affiliation or would ever collaborate with any political group to mislead the public. Please notify us if there is an issue with the transcription.